Welcome, everyone, and thank you so much for joining us this evening for the Constitution Day keynote address with Professor Melissa Murray. My name is Dr. Lauren Velasco, and I'm an Associate Professor of Political Science and Faculty Co-Chair of the Constitution Day Planning Committee. Since 2006, under Professor Emerita Linda Wharton's leadership, Stockton has commemorated Constitution Day each fall with a keynote address. Every year, we are able to learn from prominent legal scholars, practitioners, and journalists as they discuss the most pressing constitutional issues we face today. We are so proud of this Constitution Day legacy at Stockton, and we are happy for all of you to be in this room with us as you exercise your civic commitment to learn more about our democracy and the constitutional foundations that inform it. This annual event requires a great deal of work from a dedicated team. It is my great privilege to work alongside Faculty Co-Chair Dr. Claire Abernathy, Associate Professor of Political Science, and Staff Co-Chair John Frungen, Executive Director of the William J. Hughes Center for Public Policy. Although Dr. Abernathy could not join us tonight, I want to acknowledge her leadership and steadfast commitment to civic engagement as the Faculty Chair of the American Democracy Project and my co-chair on this committee. I also want to thank all of the members of the Constitution Day Planning Committee for their excellent work to make this happen. This includes key staff from event services, production services, university relations and marketing, development and alumni relations, and our faculty colleagues. This year, we are also pleased to have 4 undergraduate Constitution Day Fellows supporting the event. So thank you to Angelina Clancy, Raneen Rehani, Jenna Samis, and Joseph Wozniak for your valuable contributions this year. As we begin our keynote event this evening, I'd like to share a couple of announcements. At the conclusion of Professor Murray's address, we will have 15 to 20 minutes available for audience Q&A. On your seat, you will find your pocket Constitution and tucked inside an index card, as well as a pencil. We will have volunteers circulating to collect your note cards, so just raise them and we'll have someone pick them up. Sarah Farrow, Director of Alumni Relations, will pose your questions to Professor Murray. We ask that you all stay for the duration of the event, Professor Murray's keynote address, and the Q&A portion to follow. We expect the event to conclude by 7:30. It is now my honor to turn things over to President Joe Bertolino, who will be introducing our keynote speaker, Professor Melissa Murray. Professor Bertolino joined us this year as Stockton's 6th president. At our fall faculty conference this September, President Joe reminded us that our institutions of higher education, which provide critical spaces for democratic engagement, are under attack. And in an email to the Stockton community after the US Supreme Court struck down affirmative action earlier this year, President Joe emphasized that, quote, varied perspectives build a stronger, inclusive campus community where we all value each other. And he renewed our university's commitment to developing engaged and effective citizens. Now, more than ever, we are grateful that our leaders in higher education, like President Joe, support events such as Constitution Day to help us promote civic engagement and foster deliberative dialogue on the most pressing political issues of our time. We look forward to this being the first of many Constitution Day events with President Joe, whom I'd now like to welcome to the stage. Please join me in welcoming President Joe to the stage to introduce our keynote speaker.
Good evening. Thank you very, very much for the opportunity to be here. Thank you, Professor Velasco. And hello to our faculty, staff, students, alumni, and guests to Stockton University's 18th annual Constitution Day event. Dr. Sass and I are delighted to be here with you as we experience our very first Constitution Day here at Stockton University. As you already heard, I'm President Joe, as I am known as here at the institution, and I am delighted to welcome you all to this wonderful event, which underscores Stockton's commitment to developing engaged and effective citizens. It is our responsibility as an institution of higher education to help our students and community better understand the world around them, adapt to change, and learn from a diverse array of perspectives. The strength of democracy relies on all of us to be educated on the issues that affect not only our community, but those beyond our state, region, and nation. To understand that our actions and our inactions have lasting consequences that can impact our communities for generations to come. To actively seek out opportunities to engage with those who may look differently, act differently, think differently than us matters. And to remember that there is far more that unites us than divides us. As the times change and technology advances and misinformation moves quicker, it is imperative that we in higher education provide the spaces for difficult conversations to transpire. Colleges and universities like Stockton have the responsibility to look at issues from all sides, provide well-researched and accurate information, allow for important dialogues to occur, and extend grace to all viewpoints, giving a chance for each voice to be heard. Some of the issues we as Americans face can be uncomfortable to talk about. There are some topics some of us would like to leave untouched, unexamined, ignored. There are some topics that you may think, I don't think I can have a productive conversation about that. But ignoring issues does not mean they cease to exist. Ignoring the issue does not solve any problems, and ignoring the issue does not lead to growth. Character is built in the difficult conversations, in the uneasiness of gathering information, in the nerve-wracking task of hearing the sometimes harsh realities our friends and neighbors face. Some of these conversations happen every day within our classes, in our meeting rooms, and in the work that our faculty, staff, and students produce to inform those around us. And some of those conversations, I'm sure, will happen after hearing from tonight's Constitution Day keynote speaker. Melissa Murray is the Frederick I. and Grace Stokes Professor of Law at NYU School of Law. There, she teaches constitutional law, family law, criminal law, and reproductive rights and justice. Her writing has appeared in a range of legal and lay publications, including the Harvard Law Review, the Yale Law Journal, the New York Times, the Washington Post, and The Nation. Murray serves as a legal analyst for MSNBC and is a co-host of Strict Scrutiny, a Crooked Media podcast about the Supreme Court. A graduate of the University of Virginia and Yale Law School, Murray clerked for Sonia Sotomayor, then a judge of the U.S. Court of Appeals for the Second Circuit, and Stefan Underhill of the U.S. District Court for the District of Connecticut. She is a member of the American Law Institute and the New York Bar. The consequences of the Supreme Court's 2022 decision in Dobbs versus Jackson Women's Health Organization continue to reverberate around the country. Tonight, Professor Murray will examine how the impact of this ruling is not restricted to women's rights or reproductive rights. The Dobbs decision comes as the court has issued anti-democratic decisions, including on voting rights and redistricting. Professor Murray will explore how these realities intersect, making it much harder for state or national policy to reflect majority views on abortion, voting rights, civil rights, and many other issues on the political agenda. I'd like to thank you all for coming this evening to fulfill your civic duty of remaining educated on the issues that impact our nation. I'd also like to thank the Constitution Day Committee, including our co-chairs, Professor Claire Abernathy and Professor Lauren Belasco, and Director John Frugian, for planning this important event and securing a renowned speaker on a very timely and important issue. And my thanks to you, Professor Murray, for being here with us tonight to shed light on the impact of Dobbs on our democracy. Please give a warm Stockton University welcome to Professor Murray.
Thank you so much for having me here today to celebrate Constitution Day. President Joe, thank you for that very warm welcome. Vice Provost Teresita Sass, thank you for welcoming me to the campus. And I'm especially grateful to Professors Claire Abernathy and Lauren Belasco for organizing everything and having it flow so seamlessly. You have wonderful students here at Stockton. I had the pleasure of meeting them this afternoon in class, and I can say if your mission is to prepare engaged and educated citizens, check, mission accomplished. They were everything and more. So thank you so much for the chance to engage with them today. It is an absolute delight to be here. The article that I am going to be lecturing from today is an article that is forthcoming in the Harvard Law Review that is co-authored with my strict scrutiny co-host, Catherine Shaw, and it's called Dobbs and Democracy. The piece considers the Supreme Court's recent decision announced on June 24th, 2022 in Dobbs versus Jackson Women's Health Organization, in which a 6-3 majority of the United States Supreme Court upheld Mississippi HB 1510, a bill that prohibited abortion at just 15 weeks, and also, by a 5-4 vote, overruled Roe versus Wade and Planned Parenthood versus Casey, once the twin pillars of the court's abortion jurisprudence. In 1973 in Roe, a 7-2 majority of the court concluded that the unenumerated right to privacy confers a constitutional right to choose an abortion. In 1992, despite an explicit invitation to overrule Roe, the Supreme Court instead affirmed it, doubling down on the view that the Constitution recognized a woman's right to choose an abortion as a matter of both bodily autonomy and as a matter of sex equality. When the Casey Court upheld Roe, it noted that its decision was duty-bound, in part by the principle of stare decisis. Latin for let the decision stand, stare decisis is the view that insists that in order to ensure predictability and continuity in the legal system, past decisions must be maintained, even if the current court disagrees with them. However, the court has also allowed that there may be quote-unquote special justifications that warrant departing from stare decisis and earlier precedents. In Dobbs, the court departed from nearly 50 years' worth of precedent and a line of cases that had recognized and upheld the constitutional right to abortion. So what were the special justifications that the court enumerated to justify its decision in Dobbs? Justice Samuel Alito's majority opinion in Dobbs repeatedly claimed that the court's 1973 decision in Roe recognizing a constitutional right to abortion had preempted debate and state legislative deliberation on the issue of abortion rights, and he insisted that democratic deliberation was and should be the proper mechanism for resolving the competing interests at stake in the abortion debate. Put simply, according to the majority, Roe, and then Casey, had wrested the vexed issue of abortion from the people, misguidedly enshrined it as a fundamental right, and in so doing, cut off the people's right to debate this issue amongst themselves. On this account, in overruling Roe and Casey, the court was doing no more than rightfully returning this question to the people and the prospect of true democratic deliberation. Now, Justice Alito's invocation of democracy and democratic deliberation had undeniable rhetorical power. It allowed the Dobbs majority to lay waste to decades' worth of precedent while rebutting charges of judicial imperialism. Indeed, it casts the majority in the posture of juridical heroes, purportedly restoring the people's voices. But in this lecture, as part of our charge on Constitution Day to interrogate the court and its decisions, I wish to interrogate Dobbs's claims to vindicate principles of democracy. And to do so, I will examine the opinion's reliance on this narrative of disrupted democratic deliberation, the intellectual pedigree of that argument, the opinion's substantive vision of democracy, as well as the other purposes the court's invocation of the values and vernacular of democracy might serve as we proceed together into a post-Dobbs future. So, by way of a roadmap, I'm going to first consider the Dobbs majority's reliance on the argument that Roe and then later Casey disrupted ongoing democratic deliberation on the abortion question. As I'll explain, the Dobbs majority insisted that this critique had always attended Roe. But as I'll explain, this argument was never in the forefront in the immediate aftermath of Roe. Rather, it emerged years later through a series of legal and political developments that were aimed at discrediting and ultimately toppling Roe and Casey. And in toppling Roe and Casey, I'll argue, the reliance on this narrative of disrupted democratic deliberation may have profound consequences for the court's jurisprudence going forward. Having identified the intellectual origins of that democratic deliberation argument and its contemporary consequences, I'll then move to consider the Dobbs majority's substantive vision of democratic deliberation. As we explain in the paper, although Dobbs traffics in the rhetoric of democracy, its conception of democracy is both internally inconsistent and extraordinarily myopic. This cramped and anemic conception of democracy is even more pronounced when considered alongside the court's recent and active interventions to distort and disrupt the electoral landscape. On this account, Dobbs purports to return the abortion question to the people at precisely the moment when the court's own actions have ensured that the political landscape is unlikely either to produce genuine deliberation or to yield truly democratic outcomes. Finally, I will consider what the Dobbs majority's preoccupation with democracy and democratic deliberation may mean for the future of reproductive freedom. A close examination of the opinion suggests that the majority may have employed the values and vernacular of democracy not simply as a vehicle for restoring the abortion question to the people, but perhaps for more cynical purposes. As I'll explain, the majority's embrace of democracy and democratic deliberation not only shields the overruling of Roe and Casey from claims of judicial activism and overreach, it may also lay the groundwork for the eventual vindication and protection of fetal personhood. With that in mind, the Dobbs majority's purported state-by-state settlement of the abortion question is unlikely to be a lasting settlement. Indeed, aspects of this opinion suggest that this settlement is merely a way station en route to a more permanent resolution, the recognition of fetal personhood and the total abolition of legal abortion in the United States. So, with that in mind, let me first discuss the history of disrupted democratic deliberation. As I suggested in the roadmap, the Dobbs majority makes much of the notion that Roe and then later Casey disrupted ongoing debate at the state level over abortion rights. As the majority tells it, in the late 1960s and early 1970s, the question of abortion rights is being debated throughout the country. That is until the court in 1973 in Roe decided that abortion was a constitutionally protected right, depriving the people of the opportunity to decide for themselves whether and how abortion would be regulated. Now, to be sure, scholars like Linda Greenhouse and Mary Ziegler and Reva Siegel have disputed the claim that there was serious democratic deliberation on the abortion question occurring before 1973. As they explain, there was deliberation, there was some engagement, but by the time the 1970s rolled around, much of this had sputtered and stalled at the state level. But critically, This notion of disrupted democratic engagement undergirds much of the Dobbs majority's disdain for Roe, and ultimately, it underwrites the majority's decision to overrule the embattled 50-year-old precedent. Indeed, the view that Roe disrupted ongoing democratic debate is such a well-worn trope in discussions of abortion rights that many, including the Dobbs majority, take for granted that such a critique has always attended Roe. But is that correct? In the immediate wake of Roe, few people were focused on the question of frustrated popular debate. Instead, most critics of Roe focused instead on what they viewed as the court's misguided understanding of fundamental rights. The view that Roe disrupted ongoing democratic deliberation on abortion surfaced only briefly and only in one dissent, Justice Byron White's dissent in Doe versus Bolton, a companion case to Roe versus Wade. In that dissent in Doe versus Bolton, Justice White maintained that the court's decisions in Roe and Doe had, quote, stripped the people and the legislatures of the 50 states of the opportunity to weigh the relative importance of the continued existence and development of the fetus on the one hand against a spectrum of possible impacts on the mother on the other hand, end quote. Such a vexed and sensitive issue, White intoned, was better left with the people and the political processes. But to be clear, in the immediate aftermath of Roe, White was largely alone in voicing this concern that the Roe court had usurped an issue that was best left to the state legislatures and to the people. And White soon abandoned this particular hobby horse to further the view that so many others held, that the mistake that the Roe court had made was in advancing a misguided fundamental right. In this regard, White aligned himself with most juridical and scholarly critiques of Roe, including famously Professor John Hart Ely's Yale Law Journal essay, The Wages of Crying Wolf, which lambasted the Roe court's identification of a fundamental right to abortion. This is all to say that, at least in the immediate aftermath of Roe, critiques of the decision focused principally on the process of divining and recognizing constitutional rights, not the disruption of the people's prerogative to decide certain issues. Indeed, it would take roughly 10 years for the critique of Roe as disrupting ongoing democratic deliberation on the abortion issue to surface concretely. But surface it did. In the mid-1980s, perhaps buoyed by the court's changing composition and the growing number of Roe skeptics among the new justices, Justice White reprised his earlier position that Roe usurped state legislative authority to decide the contested abortion issue. And he did so in a conscious attempt to connect democratic deliberation to a more controversial point about stare decisis and the court's obligation to adhere to past precedents. Dissenting from the court's 1986 decision in Thornburg versus ACOG, Justice White reiterated his view that Roe, quote, departs from a proper understanding of the Constitution. But meaningfully, Justice White also went further to make the case that stare decisis considerations and obligations to defer to precedent were less weighty and pressing in circumstances where the court was exercising its judicial power to, quote, restore authority to its proper possessors by correcting constitutional decisions that, on reconsideration, are found to be mistaken. Put differently, stare decisis doesn't count when you're overturning a decision that deprived the people of its authority. White's position, with its implications for stare decisis, was well received by some members of the newly constituted court, but it made even more of an impact outside of the court's marble walls. In the immediate aftermath of Roe, the pro-life movement immediately mobilized around various efforts to overturn Roe, frontal attacks that included pressing for a federal constitutional amendment that would overrule the decision, abolish abortion, and recognize and protect fetal life. But in the late 1970s, all of these efforts stalled, completely unavailing. And so abortion opponents adopted new strategies that would be more palatable to the broader public than fetal personhood and the prospect of abolishing entirely abortion access. One strategy, championed by a young and enterprising Justice Department lawyer named Samuel A. Alito, involved chipping away at abortion access through regulations that made abortion increasingly difficult, expensive, or logistically complicated, both to provide and to access. But a second strategy sounded squarely in the register of democratic deliberation, and it focused on the idea that Roe had involved impermissible judicial overreach and that abortion was and should be a matter for states to address. To be sure, for many in the pro-life movement, this newfound appeal to state-level democracy was a second-best intermediate position, one that was fundamentally incompatible with the substantive position that the fetus was a person and that any process that terminated a pregnancy was tantamount to murder. But with the prospect of a clear frontal attack on Roe and a constitutional amendment well out of reach, many viewed this intermediate position as a necessary way station on a path that could lead first to Roe's reversal and then to the elimination of all protection for abortion. And so, taking the long view, the movement hitched its wagon to the North Stars of democracy and popular deliberation. And in Dobbs, we see this discursive strategy coming full circle. The appeal to democracy was a critical component of the majority's justification for overruling Roe and Casey. But the appeal to democracy may have jurisprudential implications that go beyond simply overruling these two precedents. Planned Parenthood versus Casey did more than simply reaffirm Roe. As Justice Brett Kavanaugh noted at his confirmation hearings, Casey was precedent on precedent. It identified a series of factors that federal courts should consider in determining whether to maintain fidelity to an extant precedent. Among the stare decisis factors that Casey identified were the quality of the decision's reasoning, its practical workability, reliance interests, significant developments in related principles of law, or the emergence of new facts or special considerations that robbed the old rule of significant application or justification. With those indicia in mind, one way that we might understand Dobbs and the majority's preoccupation with democratic deliberation is that it serves as a special consideration that justifies departing from the edicts of stare decisis. Put differently, as in Dobbs, an earlier precedent's arguable interruption of democratic deliberation on a sensitive or divisive issue may qualify as a special justification or consideration that blunts the stare decisis force of an earlier precedent. A second possibility is along the same lines, but perhaps even more alarming, and that is that the court's invocation of democracy and democratic deliberation gestures towards an entirely new standard for stare decisis in constitutional law. On this account, a past precedent is not entitled to stare decisis effect where its subject matter involves an issue that the court believes to be of high salience to the American people and where, in the court's view, the earlier precedent interrupted the prospect of democratic deliberation on that issue. An entirely subjective interrogation. And that interrogation begs yet another question. If we are to determine what decisions are entitled to stare decisis effect based on what the court believes to be an issue of high salience and where the court believes there has been interrupted democratic deliberation, what prior precedents might be affected by a court that is increasingly willing and perhaps even eager to identify such considerations that justify departing from precedent? If the court's new vision of stare decisis is concerned with an issue's importance to the American people and whether an earlier opinion usurped the power to address a question of profound moral and social importance, then it is highly likely that Obergefell versus Hodges, in which the court held that the Constitution did not permit states to restrict civil marriage to opposite-sex couples, is high on the list of possible targets. The court decided Obergefell in 2015 in a moment of undeniable churn in state marriage laws. As Chief Justice Roberts intoned in his dissent in Obergefell, the Obergefell majority, quote, seized for itself a question the Constitution leaves to the people at a time when the people are engaged in a vibrant debate on that question, end quote. Of course, the present court is differently constituted than the Obergefell court was. But these personnel changes do not necessarily dispel anxieties about fidelity to these recent precedents. Although one of the Obergefell dissenters, Justice Scalia, is no longer on the court, 3 other dissenters, the Chief Justice and Justices Thomas and Alito, comprise the core of a conservative supermajority. Further, the addition of 3 new justices whose own views of stare decisis have affected significant changes in the court's jurisprudence suggests that there is a strong majority that, at the very least, might be willing to consider whether judicial resolution of marriage equality went too far, frustrating the will of the people. Of course, the Dobbs majority's interest in democracy and democratic deliberation arguably goes beyond furnishing justifications to depart from stare decisis. At some level, the majority's interest in restoring the abortion question to the democratic process reflect its view of democracy and its view that democracy, rather than jurisprudence, is the best way to resolve this vexed question. But that also begs a question. What is the Dobbs majority's vision of democracy? The Dobbs majority opinion subscribes to what I view as an extraordinarily anemic and myopic conception of democracy. And this myopia has multiple valences. It is an institutional myopia, it is a directional myopia, a political myopia, and a methodological myopia. Let me explain what I mean by all 4 of these. First, institutional myopia. When the Dobbs majority discusses democracy and democratic deliberation, it focuses almost exclusively on state legislatures, repeatedly invoking those bodies as the paradigmatic representation of democracy. Yet, as the result of gerrymandering, state legislatures are often the least representative institutions in state government. And the court's emphasis on state legislatures as arbiters of democracy belies the role that state judiciaries may play in interpreting state constitutional provisions to protect reproductive rights. It also belies the role that state executive officials, governors, and attorneys general might play in enforcing and vetoing restrictive abortion policies. And critically, in many states, judges and executive actors run for office statewide and are elected by many more voters than the average member of a state legislature. In addition to this inattention to these other constitutional actors at the state level, the Dobbs court conspicuously makes no mention of direct democracy. But as we know, in Dobbs's post-landscape, a number of states have used ballot initiatives and voter referenda to protect reproductive rights under state law. And the success of direct democracy to do so has prompted a backlash where states are now seeking to limit the use of direct democracy when it is done for the purpose of preserving or expanding reproductive freedom. The Dobbs majority's neglect of these other state-level constitutional actors and the prospect of direct democracy reveals yet another form of myopia, directional myopia. The court understands democratic deliberation on abortion rights to proceed in only one direction, toward the further restriction of abortion rights. It does not even conceive of the possibility that such deliberation might lead to the preservation or even the expansion of reproductive freedom. And this is especially curious, given that the majority's repeated reminders explain that before Roe, debate was occurring and proponents of liberal abortion rights had succeeded in some measure in persuading their fellow citizens of the rightness of their cause. This narrative of democratic deliberation that was disrupted makes clear that this kind of deliberation might run in both directions, both for restriction and for expansion. Yet the court speaks only of the prospect of democratic deliberation as limiting abortion rights and reproductive freedom. The majority opinion is also myopic in its understanding of political power, which it reduces to the act of voting, or perhaps running for office. In the opinion, Justice Alito notes that when it comes to political participation, women are registered to vote and turn out to vote at higher rates than men. On this logic, he insists, if women are unhappy with the Dobbs decision, they need only get themselves to the ballot box to change things. But is that the nature of political power? Even putting to one side the significant obstacles that women, who are often the primary caregivers in the family, must surmount to actually exercise the franchise or to run for political office. If we use any metrics beyond simply showing up to vote to measure democratic participation, the empirical portrait of women's political power looks decidedly different. For example, women are grossly underrepresented in state legislatures and in Congress. They are grossly underrepresented in state and federal executive positions. They are grossly underrepresented in state and federal judicial posts. Women are also woefully underrepresented in the ecosystem that surrounds mainstream politics. They are a minority of federal lobbyists, and they donate to political campaigns at far lower rates and in lower amounts than do men. That's the political power that I'm thinking of, what it actually takes to make change, not simply showing up at the ballot box. And yet, that kind of political power is completely absent. That understanding of it is completely absent in the majority opinion. And then finally, to compound all of these myopia, the decision is myopic in its methodology for understanding constitutionally protected rights. In addition to advancing an uncritical and facile vision of political power and its exercise, the court's vindication of democratic deliberation prioritizes and privileges moments of democratic debate that included only some members of the political community. For example, when the Dobbs majority insists that Roe interrupted state-level debate and deliberation on the abortion issue, it is often referring to mid-century debates over whether to repeal or liberalize then extant abortion restrictions. What is missing from the court's account of these debates is the fact that the laws and policies being debated in the 1950s and 1960s were enacted a generation earlier through democratic processes that were categorically closed to all but white men. On this account, the debates that Roe allegedly preempted and that the Dobbs majority prioritizes and seeks to vindicate in returning the abortion question to the states are debates over whether to retain or liberalize laws that were enacted under conditions of extreme democratic deficit. Relatedly, the history and tradition method the Dobbs court uses to hold that the Constitution does not protect a right to abortion itself reveals a hollow commitment to democracy. The Dobbs court's attention to history and tradition consists primarily of examining a slew of mid-19th century statutes enacted during a wave of nativist furor aimed at increasing the birth rate among native-born white women. And again, the laws that the majority cites were enacted in an era in which women could not vote, could not run for political office, and were not understood as full and equal members of the polity. Put differently, The Dobbs majority's method of analysis and interpretation binds the contemporary meaning of the Constitution for all of us to a body of law and authority in whose enactment and creation neither women nor people of color played any part. Dobbs's hollow commitment to democracy is even more pronounced when considered alongside the court's other interventions, which have actively distorted and disrupted the landscape of democracy. As we discuss in the paper, Dobbs arrives in the wake of a series of high court decisions that have blessed partisan gerrymandering, hobbled the Voting Rights Act, and made our democracy decidedly less representative and less democratic. But perhaps the most troubling aspect of the Dobbs majority's invocation of democracy is its cynicism, its deployment of the vernacular and values of democracy in service of an end goal that is decidedly out of step with majoritarian preferences that signal that 70% of Americans favor in some form reproductive freedom. So what do I mean when I say that the Dobbs majority deploys the vernacular of democracy and the values of democracy in service of a counter-majoritarian goal? In its dismantling of Roe, the Dobbs majority repeatedly references John Hart Ely's essay, The Wages of Crying Wolf. That's a curious choice because Ely is perhaps better known for his 1981 book, Democracy and Distrust, which has become one of the most cited tomes in all of constitutional law. Ely, like the Dobbs court, was deeply interested in questions of democracy. Indeed, Democracy and Distrust was a defense of the Warren Court and its decisions, particularly in the areas of voting rights and school desegregation. Ely defended those decisions on the grounds that although Brown versus Board of Education and the voting rights decisions overturned state laws that had been passed by a majority of Southerners, the decisions invalidating them were not counter-majoritarian, but rather were democracy-enhancing because they allowed individuals who had been disenfranchised and unable to participate in the political process to join in, whether as citizens in public schools or at the ballot box itself. For years, critics had argued that the Warren Court exemplified a particular strain of judicial imperialism and activism, one in which the court substituted its own judgment for that of the people, as expressed in the laws enacted by the people's representatives. Ely defended the Warren Court from these claims of counter-majoritarianism. Again, consider his defense of Brown versus Board of Education. It is unfathomable today to think that there were objections to Brown. But in 1954, when Brown was decided, it was immediately controversial because the court had invalidated laws that were enacted and again favored by a majority of Southerners. In a similar vein, the Warren Court advanced a theory of voting rights that required a recalcitrant South to enfranchise its minority voters, despite state and local preferences to do otherwise. Ely argued that although these decisions departed from the will of the people, they were nonetheless democracy-enhancing because they protected minority participation in democratic institutions, schools, and voting. Specifically, decisions like Brown and the Warren Court's voting rights decisions intervened to protect a discrete and insular minority from being completely overrun by the majority at the ballot box. These decisions, Ely insisted, perfected democracy by allowing these underrepresented minorities to participate meaningfully in majoritarian politics. But if Ely was a staunch defender of decisions like Brown, he was more skeptical of decisions like Roe. In his 1974 article, The Wages of Crying Wolf, Ely criticized Roe for lacking a foundation in constitutional law. But he did not stop there. According to Ely, Roe's other fundamental flaw was that in prioritizing the pregnant woman, the court's decision failed to grapple fully with the compelling interest in the protection of the fetus. Ely made the point even more plain in a telling passage. As he acknowledged, women, despite being roughly half the population, often lacked political power. Quote, compared with men, very few women sit in our legislatures, end quote. But, Ely noted, women's political powerlessness paled in comparison to another entity's vulnerability. As Ely intoned, quote, no fetuses sit in our legislatures, end quote. If the court's obligation was to use the power of judicial review to, among other things, protect discrete and insular minorities who were powerless to press their own interests in majoritarian processes, then Roe's vindication of the pregnant woman's rights left the fetus utterly bereft of judicial protection. And critically, this account of the fetus as an underrepresented, vulnerable constituency in need of judicial protection can be glimpsed in Dobbs. Throughout the opinion, there are repeated references to the fetus and acknowledgments that many among the public view the fetus as an unborn human being. And the logic of the fetus as a person and abortion as a murder has been elaborated in recent decisions, including in Judge Matthew Kaczmarek's much-discussed opinion in Alliance for Hippocratic Medicine versus FDA. But perhaps most telling on this front is the Dobbs majority's discussion of abortion's, quote, eugenic potential. In footnote 41 of the Dobbs opinion, the majority reiterates a view husbanded by Justice Clarence Thomas that those who seek, quote, liberal access to abortion have been motivated by a desire to suppress the size of the African American population, end quote. To be sure, the Dobbs majority's nod to abortion as racial genocide is on some level gratuitous, given that the court's decision to overrule Roe and Casey rests entirely on the view that the abortion right is unmoored from constitutional text and lacks deep roots in the history and traditions of this country. But if that footnote does not serve a jurisprudential purpose in Dobbs, it serves an important discursive purpose. It builds the case for viewing limits on abortion as anti-discrimination measures, and more importantly, for viewing the fetus as a minority in need of judicial protection. Critically then, the majority's interest in Ely's wages goes beyond simply allowing the court to reframe its actions in more politically palatable terms as democracy enhancing. It suggests that the majority's vision of democracy and democratic deliberation on abortion does not end with simply returning abortion to the states, but rather will end with an acknowledgement of the constitutional interests of the unborn. In this regard, Dobbs's invocation of democracy, of letting the people decide, alongside these other discursive maneuvers, has the broader potential to reshape, however subtly, our understanding of who is in the polity and the identity of those discrete and insular minorities whom the court is obliged to protect. And there are already hints in the opinion that this is afoot. The majority's decision to focus primarily on principles of democracy rather than on the illegitimacy of the doctrine of substantive due process may reflect a desire to preserve the possibility of later reliance on substantive due process to justify constitutionalizing a rule that would prohibit all abortions. And the court's repeated references to both fetal life and unborn human beings may be designed both to lay the foundations for constitutionalizing such a rule and to broadcast both to prospective litigants and lower courts the majority's receptivity to such claims. With all of this in mind, the Dobbs majority's democratic state-by-state settlement is likely to be just a way station and not a final destination. Instead, The true potential of the Dobbs majority's vision of democracy-enhancing jurisprudence likely will be achieved when the rights of an overlooked, discrete, and insular minority, the fetus, are finally recognized, whether through the activity of majoritarian politics or through judicial fiat. Thank you.
Thank you, Professor Murray. I'm Sarah Farrow-Crowley, Director of Alumni Relations, and I have the pleasure of moderating tonight's Q&A. Before we get started, I'd like to remind everyone to please stay seated until the end of the program, and that you all have note cards and pencils on your chairs. So please keep those questions coming. If you have one, raise it, and we have folks who are collecting them, and then we'll bring them up to the stage. And I'll now get started with the first question. Do you see the passage of the Equal Rights Amendment as a viable way to overturn Dobbs?
So, will the ERA overturn Dobbs? I just want to be very clear. This has been a very downer of a talk, I'm aware. It's only going to get more depressing. This was a movement that took a lifetime, right? Roe was decided a few years before I was born. The mobilization against Roe has been going on the entire time I have been alive. And I expect if there is a counter mobilization against Dobbs, it's going to take a similar length of time, right? So there is no immediate fix for this. Like, if you are interested in counter mobilizing against this decision, this is a situation where you are going to have to be prepared to limber up, hydrate, and pack a lunch. It's going to be a long fight. I probably won't be around for the end of this. But it happens, right? If Roe can be overruled, Dobbs can be overruled. Can it be overruled by the ERA? I'm not sure that it can, in large part because I think there will be constitutional questions about interpreting an ERA, and those questions will come before this conservative 6-3 court, right? But that is not a reason to not mobilize around the ERA. There are lots of reasons to have an ERA irrespective of abortion rights. And so, again, if you care about equal pay, if you care about Title IX and gender equity, there are lots of reasons to support an ERA, whether at the federal level, where it does not exist, or expanding it at the state level. And there are lots of states that have state-level ERAs. Those can be expanded. States that don't have them could enact them. Those are all really important steps, and I think particularly at the state level ERAs can do a lot to further the interpretation of state constitutions in ways that favor and preserve and enhance reproductive freedom. But there is no magic bullet for what has happened. Like, there's only going to be putting your back into it and getting to work.
Thank you. Could you discuss the state initiatives such as ballot initiatives and constitutional amendments that are happening to protect reproductive freedom and the role you see them playing to secure abortion rights?
Sure. The question about direct democracy is a really important one, especially given the court's nod to democracy. Like, ostensibly, letting the people decide would be a good thing, right? And we have seen that happen in the post-Dobbs landscape. I want to just be very clear. Not every state has the mechanism for direct democracy. Many states do not. The states that do have it, we have seen it move in certain directions, but we've also seen incredible backlash to this. Ohio is a great example. Just recently in Ohio, there was a grassroots movement to put on the ballot for November a proposed constitutional amendment that would amend the Ohio State Constitution to preserve abortion access and reproductive rights. And then apparently the state legislature created an August election. They'd previously eliminated August elections because they thought that the low voter turnout would be bad for democracy, but they reinstated it so they could put a single question on the ballot in August, which was to raise the threshold for enacting constitutional amendments from 55, I think it was 50 or 55% to 60%, so to make it a super majority. And the reason they did that was because it was the proposed amendment was polling at about 58%. So again, to make it harder. That was defeated in August, but it's happening all over the country. Anywhere where there's the possibility that the people might use direct democracy to further reproductive rights, there's a backlash. So in Mississippi, for example, the Mississippi Supreme Court had eliminated direct democracy in that state. It was recently reinstated, but with one caveat: it could not be used to expand reproductive freedom or for any issue related to reproductive freedom. So very telling in that respect. And I also just want to say, this is not, a plug for direct democracy that's like amazing. Direct democracy has actually been used by conservatives throughout the country to advance projects that I think lots of people in the majority would actually disagree with and would take issue with. And direct democracy can be very tricky. The way you word referenda and ballot initiatives can really be misleading to the public in a lot of ways. So we've seen this in California. Prop 8, which eliminated same-sex marriage in California, was a voter initiative. Proposition 209, which eliminated affirmative action in the state of California, also a voter initiative. So it is telling that in this moment, when direct democracy is being used to advance reproductive freedom, the very people who for years used direct democracy to advance their own agenda items are now turning their back on it and trying to foreclose it. So there's that.
Thank you. If the Supreme Court continues down the road of overturning rights in the name of democracy, such as gay marriage, as you discussed, what can we do to fight back through these democratic processes when gerrymandering and voting right erosion have taken hold?
Okay. Again, another depressing answer. First, let me just say, the court doesn't just overrule things, right? A decision like Dobbs is very unusual. More likely, what the court will do is narrow a precedent to the point where it's a nub of what it once was and it can't do anything. Or sometimes they do what you young people might understand as ghosting a precedent, which is to say that it won't cite a precedent or won't use it in cases where it's very clearly relevant, right? So one example of this was in a recent case about the praying football coach in Seattle, Coach Kennedy. The case was called Kennedy versus Bremerton School District. The obvious precedent there was a case called Lemon versus Kurtzman from the 1970s, which established the test for determining when the state became too entangled with religion, violating the Establishment Clause separation of church and state. The court didn't cite Lemon in a number of Establishment Clause cases before it reached Coach Kennedy's case. And then when the school board cited the Lemon test in their briefs before the court in its decision ruling for Coach Kennedy said, this Lemon test, it's been abandoned. It's been absolutely abandoned. No one's following the Lemon test. What the court doesn't say is they're the ones not following the Lemon test. If the Lemon test is abandoned, they did the abandoning. They literally put the Lemon test in a drop box and left it at a fire station. It's over. So the court does that a lot. There's a case that's now pending before the court called Loper Bright Enterprises versus Raimondo. And in that case, the court is explicitly being asked to overrule Chevron versus Natural Resources Defense Council, which is a 1984 decision that suggests that when a statute is ambiguous, the administrative agency charged with interpreting or regulating under that statute gets the last word in interpreting what it means, right? Chevron was decided in a way that actually favored the Republican administration when it was decided, but since then it's become a kind of bête noire of the conservative legal movement, and they would like for it to be overruled. A few terms ago in West Virginia versus EPA, a big case concerning the Clean Air Act, everyone expected the court to cite Chevron, even just a little bit. They were conspicuously silent, not one mention of Chevron, which leads me to believe that when this new case is decided this term, it will be very easy to overrule Chevron because they ghosted Chevron a long time ago, and they'll just say Chevron has been abandoned. So it's not always like we formally overrule something the way that they did in Dobbs. It's narrowing, it's massaging, it's pivoting, it's ghosting. So there are lots of ways that you can play with precedent while still ostensibly being faithful to stare decisis. There's a lot of emotional cheating on precedents, right? So you have to understand that. What then can we do if this is a court that seems unrestrained by the edicts of stare decisis. What can we do, especially when the democratic landscape is so distorted? The distortion is real, its impact is enormous, and it means that you have to work that much harder to turn out voters to counteract the impact of the distortion. So there's no way around this but through it. More work, more people, getting them to the ballot box. There's a reason why there are so many jurisdictions around the country that are working at limiting the availability of the ballot box near or adjacent to college campuses, because they're afraid of what college students will do when they go to vote. They will make it harder to vote near college campuses. The lines will be longer. They know you have classes, they know you have other things. They will make impediments to vote. You have to stay with it. That's the only way to overcome the distortions. You have to have more numbers, more people voting.
Thank you. Do you believe the sweeping impact of the Dobbs decision has had an effect on the breadth of subsequent court rulings in other areas, such as affirmative action, environmental protection, or student loan forgiveness?
So you would think that after overruling a major decision, the court was sort of like, you know what, we're going to slow down a little bit, have kind of a breather of a term. And typically, that is the usual rhythm of Supreme Court terms, like a big term where they decide something major is followed by something more muted, where the cases are perhaps more anodyne, not quite the blockbuster cases that MSNBC hauls me out to talk about. Like in a normal world, I'd have a big season and then I'd just go back to my normal life and not be on TV. We are not having a normal one with this court, and that's a question of numbers. When you have a 6-3 conservative supermajority, you got to make use of it. At the Supreme Court, there are two numbers that matter, right? There is the rule of 5, and there's the rule of 4. The rule of 5 matters for decisions. In order to make a decision to have a majority, you need 5 justices. You just need to count to 5. But in order to take a case, to grant certiorari, because the Supreme Court doesn't have to take every case that people want to get to the Supreme Court. You petition the court, but they don't have to take your case. In order to get the court to take a case, there has to be 4 votes for certiorari, the rule of 4. Before, when the court had a bare 5-4 conservative majority, they were never really sure of where a 5th vote might come from. Both sides were never really sure. Someone could always wobble. Justice Kennedy was a very famous wobbler. Justice O'Connor also not reliable for the conservatives, not always reliable for the liberals either. They were more uncertain. And because they were uncertain, both sides had to be really careful about what cases they picked. Most sympathetic facts for their side, most developed facts, like really tight cases. You don't see that anymore because they have 6 and they don't need 5 when they have 6. When you have 6, you can peel off someone. Someone can be recused. It won't matter. They won't actually recuse. But someone could, and it wouldn't matter. And that means when they're picking cases, they're not as choosy because they don't have to be. And that's why we are getting these terms that are one barn burner after another. It's also worth noting that what's happening in the lower federal courts affects the Supreme Court's docket too. If you look at the cases pending on the court's docket this year, a lot of them are from the Fifth Circuit. The Fifth Circuit includes Louisiana and Texas, and that is a circuit that's not having a normal one either. It's a very extreme circuit. A lot of its decisions are really extreme, and that means when the court takes cases from the Fifth Circuit, it is either ratifying those decisions, so ratifying a very extreme position on constitutional law, or it's pulling back, usually just a little, which is still a very conservative position to take. So when you're taking that many cases from the Fifth Circuit, you're necessarily pushing the law in a rightward direction, even if you're not always crediting in full those decisions, because those decisions are already so far out to the right that even if you pull back a little bit, you're still right of center. Right? So there are a lot of different things that are going on, and so no, We're not going to have a more muted term. I don't think the court cares to have a more muted term. I think there are at least 2 people on this court who have been waiting for this 6-3 conservative supermajority for some time. And this is like, did you all have Golden Corral when you were growing up? I grew up in Florida. Golden Corral was a place where it was like a buffet and like just like food everywhere and steak. And like you just like ate and ate and ate. Like I guess it's like Vegas for adults. This is like Vegas for the court right now. Like, why would you stop? Make the most of this. And I think that's what they're doing.
Thank you. How does the court's departure from stare decisis in the recent affirmative action case fit into its theory when stare decisis can be ignored?
Well, so here's a question. Did the court actually overrule anything in the affirmative action case? The court never said explicitly, we overrule 2003's Grutter versus Bollinger, which said that it was okay to have the limited use of race in a holistic, individualized admissions calculus. They never actually said that. The person who said Grutter was overruled was Justice Thomas in his 60-page concurrence that was twice the length of the majority opinion, making very clear that he would have very much liked to write the majority opinion. So that's also instructive, right? The Chief Justice who wrote the majority decision in Students for Fair Admissions versus Harvard was loath to say he was overruling anything. Why is that? Because of Dobbs. So they are thinking about this, but I think Justice Thomas is likely right. It's not a formal overruling of Grutter. It's certainly an overruling in principle, if not effect, but the Chief Justice never said it. I kind of almost like Justice Thomas being straightforward with us. But yes, that's where, again, this is watching how they move and what they do. And this is a 9-member court with 9 different personalities. So you're getting 9 different approaches in a lot of ways, even as they work to get to consensus.
Thank you. This one is a little bit longer. Democracy was a component, but not all of the reasoning behind the Dobbs decision. Justice Alito took care to use prior law and judicial reasoning, reaching back to the pre-constitutional era in his majority opinion. Alongside Dobbs, in the Bruin v. Rifle Association, the court decided current gun laws must have root in the historical tradition of firearm regulation. Is this deference to history a means to an end for conservative judicial movement, or is this historical cherry-picking a new vanguard of originalism?
It's a great question. So what is the court's new fascination with history about? I think it's a strain of originalism, but it's not pure originalism. And Justice Alito, who wrote the majority opinion in Dobbs, is, I wouldn't call him the court's most stalwart originalist. I think Justice Thomas is. Justice Thomas wrote the majority opinion in Bruin. Let me say this about Dobbs's use of those older pre-founding laws. Justice Alito goes through this practice of counting state laws that existed before the 14th Amendment, and he says that there's this vast swath of laws that prohibited abortion in the United States even before the 14th Amendment. He is right to a point. Those laws prohibited abortion after quickening. Quickening was the time known in common law, this is all very loosey-goosey, but quickening was the moment where the woman could feel fetal movement within her. She was quick with child. So it's sort of basically a little bit like viability today. Before quickening, abortion was permitted. After quickening, it was not. Justice Alito does not make that distinction in counting these laws. He says there are this many laws and they all prohibited abortion. They don't prohibit abortion before quickening. So it's not quite an accurate account. So that's one account of the history that's being done. So if the question is it a kind of selective and faithful, or is it a selective and itinerant history? Yes, it is. And there were lots of briefs that explained the nature of those laws, which he didn't advert to. I'm not going to get down on him about being a bad historian because he's not an historian. In fact, none of the justices are historians. Not one of them has gone to graduate school and gotten a PhD in history or has had detailed methodological training in how to do history. But that should not then allow us to just sort of allow them to take this history and tradition methodology and say, this is how we're going to interpret the Constitution going forward. They don't have the skills for this. Carlton Reeves, who is a district court judge in the Southern District of Mississippi, had a case a couple of months ago. It was a gun rights case. And the Second Amendment, as the question suggests, is another place where this history and tradition analysis has now become a big thing for the court. Justice Reeves, or Judge Reeves, was like, I'm not an historian either. I shouldn't do this. And so he appointed a special master to do the history. And the special master is like, well, it could be this, it could be that, because history is subjective too, right? It is a contested body of, no, there's no objective answer. The court has cottoned on to this idea of history and tradition and originalism with the view that somehow it is objective and it removes judicial subjectivity. There's nothing more subjective than doing an historical analysis, and certainly in the way the court has done it. Justice Thomas is equally selective and itinerant in his approach in Bruin, ignoring all of the briefs and the evidence that are marshaled against his position and only citing those that support him. I mean, it's not good history. Any historian will tell you that. And again, as I said in the talk, there's something deeply, deeply problematic about binding our understanding of a document that's going to govern us all with a method that insists that constitutional meaning can only be divined from these moments in time where not all of us were participating. I mean, that is just profoundly anti-democratic. And so, yes, I think it's itinerant. I think it's selective. It is where we are right now. The best thing I think we can do is to flood them with history. If they're going to be historians, let's make them better historians. They're bad historians. They're really bad historians.
In addition to same-sex marriage, what other issues or rights do you see being threatened by the Dobbs precedent?
Contraception, Griswold versus Connecticut, which was decided in 1965. Basically, the entire line of substantive due process cases, that begins in 1965 with Griswold. There's Eisenstadt versus Baird, another contraception case from 1972. There's Loving versus Virginia in 1967, although Justice Thomas did not mention that one in his concurring opinion in Dobbs, ostensibly because there might be statutory reasons to protect interracial marriages, if not constitutional reasons for doing so. They're just, basically all of the decisions of heart and home that were decided under the rubric of substantive due process are up for grabs, I think, because they're unenumerated. Many of them reflect a set of rights that would not have been acknowledged in 1789 or even 1868 for that matter. Now, to be very clear, I don't know if that's the case for contraception or reproductive rights more generally. My colleague at NYU, Peggy Cooper Davis, has written a wonderful book, The Constitution and Family Values, Neglected Stories, The Constitution and Family Values, in which she argues that the 14th Amendment, and indeed all of the Reconstruction Amendments, were ratified with an explicitly abolitionist ethos. So the 13th Amendment abolished slavery, the 15th Amendment brought black men into the political community as voting citizens, and the 14th Amendment was intended to eradicate all of the vestiges of enslavement. And so to do that, the drafters of the 14th Amendment explicitly asked, what is liberty and what is enslavement? Enslavement was not having control over your children. Your children could be sold away from you. Not having the ability to marry and have it civilly recognized. Not being able to control your reproduction if you were an enslaved woman, because you could often be sexually compromised, whether by your master or made to breed for your master's purposes. So her point is, when the 14th Amendment was ratified, it was purposely to eliminate and to undo those indicia of slavery that separated free people from enslaved. And so there is necessarily a reproductive freedom component of the 14th Amendment that the Dobbs court refuses to acknowledge, and I think is very much there. So again, history is broad and encompassing, and that's not mentioned, but perhaps it should be.
When the political tide turns in a more liberal direction, do you foresee an amendment being brought up for consideration regarding reproductive freedom?
Again, that may be a long horizon. Like when the political tides turn, we're actually now in a moment of sort of even political division. So, I don't know what that looks like or how that changes. We seem like stubbornly enmeshed in these two halves. I was just interviewed for a documentary, and the premise of the documentary is like, what if we allowed the whole center of the country to secede? Like, is that the only way forward because of our political polarization? And to allow the coast to be a country and everything in the middle get to be a country too. I mean, it's a very sort of radical proposition, but it does go to show, like, I'm not sure what the future looks like and whether we are going to see a liberal majority. I think we're going to be pretty even for a long time, and we're going to have to figure out how to work and talk to each other. So there's that. I think one way to talk to each other is the way we're seeing happen in red states right now. Like when reproductive freedom goes up on the ballot in red states, it's not shut down. It's actually entertained. It's actually winning. And I think that's because if you talk about reproductive rights in the language of government overreach or government encroachment, it resonates in a different way for people on the different point of the political spectrum. And so it may not be the way people in blue states want to talk about it, but it's, I think, a very reasonable way to talk about it to people who are not necessarily inclined to be receptive to the way blue states are talking about it. But the point is, instead of hoping for a day when the liberals take over and it's the Warren Court again, and FYI, I think the whole Warren Court was super liberal is a very overstated premise. That's a different Constitution Day lecture. I think we have to learn to talk to each other. Like, we have to figure out how we're going to talk to each other.
So this is the last question that we have time for. In your view, what represents the most promising approach to overturn Dobbs? Where do you think activists and constitutional scholars should focus their attention?
Any movement to overturn Dobbs, to reverse this, is going to come from everyone here who is younger than 30. Like, truly. My generation can lay scaffolding, can provide theories, can do some of this work, but the heavy lifting is going to be on all of you. And you're going to live with this decision. Like, whatever you think about abortion, here's the bottom line. This is a necessary part of healthcare for women experiencing pregnancy loss. If you were a woman experiencing pregnancy loss and you still want to have a family afterwards, you need an abortion because you don't want to be septic and you don't want to lose your uterus. I have been there. Like, pregnancy loss is no joke, and it's a serious thing. If you care about that aspect of it, even if you're not pro-abortion or pro-choice, we can all care about that. People want to have families, and pregnancy loss happens. You are going to have to figure out how to talk to people. You're going to have to figure out how to mobilize, and you're going to have to figure out how to endure and last and be resilient and be consistent. This is not going to be an episodic fight. It's not going to be resolved quickly. This is not a one and done kind of thing. You're going to have to change hearts and minds. You're going to have to talk to people in a vernacular that may be unfamiliar to you. You're going to have to talk to them where they are. You have to appeal to a set of values that we all share, even at a time where it doesn't feel like we share much of anything. Because that's the only way that we're going to get to the other side of this. Whether you believe Roe was wrongly decided or not, women are actually dying in parking lots while doctors try to debate whether or not they have the legal authority to intervene. That should not be where we are in a country like this one. My mom was an immigrant. Both of my parents were. They came from Jamaica. My mom came here in the 1960s to be a nurse on a special visa because there was a nursing shortage here in the US. I don't think she ever imagined that we would be in a situation like this. My mom died in April, and before she died, she had serious Alzheimer's and was just not able to sort of register the world around her. And as terrible as her Alzheimer's was, for that, it was a blessing. Because to have someone who spent her life working with women, caring for children, trying to help them in the worst moments of their lives, I think she would have been so devastated to see where we had come, where her daughter and granddaughter were in this landscape. Like, she came to this country for opportunities for herself, for me, for her future grandkids. To see how quickly the tide could turn is just jarring for anyone, but especially for people who truly do believe that this is a country of opportunity. I believe it is a country of opportunity. I believe even in this moment of polarization and challenge, we can come together and we can find a way forward together, and I hope that we do that. I hope this lecture has helped provide you with language and vernacular to talk about this, to challenge other points of views, but to do so respectfully and with evidence, and to arm yourselves for a fight that shouldn't be a fight, but will likely be a fight, but to do so with a purpose of love and engagement for yourselves, for your country, and for all of us. So thank you.
Great. Oh, Professor Murray, we appreciate you sharing your time and expertise with us this evening. Thank you for celebrating Constitution Day with all of us here at Stockton University. I want to invite Dr. John Frugin up, Executive Director of the Hughes Center for Public Policy, for a few closing remarks.
Thank you, Sarah. You know, Constitution Day is always one of the biggest events at Stockton. It's always one of the most important. And I think, given where we are today, it's more important than ever. Our society is so polarized, democracy is under threat, and friends and family can't even talk to each other anymore about politics. So for these reasons, the Hughes Center is so pleased to be part of Constitution Day. And we are all about civic engagement and informing the public about important issues. Our late namesake, Congressman and Ambassador Bill Hughes, was passionate about civic engagement, and he understood that democracy had to be cultivated, that we couldn't take it for granted. And so he thought it was very important that the Hughes Center work to create an informed citizenry. I think by Ambassador Hughes' standards, today's Constitution Day was an unqualified success, and I congratulate Stockton for upholding this important tradition. Thank you, Professor Murray, for a thought-provoking address and for spending time with our students today. And a special thank you to our faculty co-chairs, Drs. Lauren Belasco and Claire Abernathy, for all their hard work. And thank you all for supporting us, and good night.